Good evening, everyone.
Good evening, sir.
Good evening, sir.
Good evening, sir.
Good evening. So, should I start now?
Yes, sir.
Yes, sir.
Okay. So, guys, the first portion in the chapter one, because if you remember, I told you कि chapter one के दो part हैं. पहला part basic understanding of competition law, history and development of competition law, salient feature of competition act, and the difference between MRTP Act and the Competition Act. So अभी तक हमने जो है डिस्कस किया बेसिक अंडरस्टैंडिंग ऑफ द कंपटीशन लॉ एंड हिस्ट्री एंड डेवलपमेंट ऑफ द कंपटीशन लॉ आल्सो वी हैव डिस्कस्ड. नाउ इस टॉपिक से और एक और भी जो था उसमें दैट कॉन्स्टिट्यूशनल एस्पेक्ट. यस मोनिका, यू हैव टू म्यूट योरसेल्फ. ठीक है. So the constitutional aspect of elimination of wealth, article 39b and c, so that aspect also we had discussion on that. Now there are only portions or two things remaining in the this first part. One is the difference between MRTP Act and Competition Act, and the another one is the salient feature of the Competition Act 2002. So first I'm taking this salient feature of the Competition Act. और ये जो क्वेश्चन है आपको 10 मार्क्स में पूछ सकता है. कई बार ये क्वेश्चन पूछता है व्हाट आर द सैलिएंट फीचर ऑफ द कंपटीशन एक्ट 2002. सो बड़ा ही सिंपल क्वेश्चन है. एंड फ्रॉम द perspective of स्टूडेंट ऑफ कंपटीशन लॉ आल्सो आपको ये पता होना चाहिए कि कंपटीशन एक्ट 2002 जो कि इनेक्ट हुआ एमआरटीपी एक्ट को रिपील करके, तो ऐसा इसके अंदर क्या नया है, क्या स्ट्राइकिंग फीचर है, क्या यूनिक पॉइंट है. ओके, few points we will discuss. Now we know that in 1969 Monopolies and Restrictive Trade Practice Act was enacted with the objective of prohibiting the monopolistic behavior and the restrictive trade practices behavior. And after the 1984 amendment, the unfair trade practices behavior were also included, and that was also prohibited. So the object of the MRTP Act was to preventing certain types of the behavior in the market so that the enterprises or the market player can compete with each other. But with the changing circumstances, and that changing circumstances was economic reform, it was felt that the act we have MRTP is not sufficient to create the competitive behavior in the environment, behavior in the market. And so it should be repealed and we should have a law that is at par with the international standard. The law जो कि अमेरिकन लॉ और यू यूरोपियन यूनियन लॉ के बराबर हो. And so competition act was enacted with this particular objective, to achieve this objective on the recommendation of Raghavan committee. Now there are some very striking feature, there are some salient feature of the competition act. The first one is the extraterritorial applicability. Extraterritorial applicability, or you can say a long arm provision. Extraterritorial. Extraterritorial means beyond your territory. Even if there is a law that has the effect on some activity that is beyond your territory, beyond the territory of the India, is known as the extraterritorial law. Now, whether this extraterritorial law is legal or not, constitutional or not, that is a constitutional question. But इतना मैं बता देता हूं, in the constitution, the center and state relationship, there is one part, one chapter related to legislative relationship, and article 245 and 246 are important. That the center can make the law for whole of India or any part of India, and state can make law for the whole of the state or the part of the state. And so the law made by the parliament can be for whole India or any part of the India. And then in the second clause, it is written that if the law has the extraterritorial effect, only on this point it will not be considered as unconstitutional or illegal. But if you see from the practical aspect, to making law effective, you need that it should be implemented. It should not be only a piece of paper. If you make a law, that only a piece of paper, because you cannot execute it. So that is also not that should not be the purpose. And so in the constitution, the principle is that if the parliament make a law and it has extraterritorial effect, it always have the territorial nexus, and the nexus in form of the effect. Maybe the activity we are punishing, like in the criminal law. In the criminal law, in the IPC, if you remember, there are the three types of the jurisdiction. One is that the tribability on the basis of the territory where the offense is committed. So suppose offense is committed on the Indian soil, Indian court will have the jurisdiction. Indian court will have the jurisdiction irrespective who committed the crime. Suppose an American came in India for visit as a tourist. He commit the rape of another tourist who is from France, by any country. So the offense of the rape is committed in India, and this person will be prosecuted in India. If the person who came from Japan killed an Indian, he will be prosecuted in India, because the act he has committed is prohibited by our law. And the basis of this tribability is that the offense is committed on the territory. Okay. So this is on the basis of territorial jurisdiction. And here, even if the act is committed outside, but the territorial nexus you know that you fix, establish. Suppose there is a person who was standing on the Nepal side of India, and from there he fired a bullet and it killed an Indian. So where the offense is committed, now here, will you consider the offense is committed from where the bullet is fired, or from, or the offense is committed where the result of that bullet is caused, the effect of that activity is caused. And so there the effect doctrine is applied. And as per the effect doctrine, we will consider that this act, though may be outside some part, but its effect is on the Indian soil, and so Indian court have the jurisdiction. The criminal law may a principal effect doctrine. Similar type of the territorial nexus we have to provide for other statute also. If we are imposing some liability, if we are imposing some any criminal or civil liability, there must be territorial nexus. Otherwise there is no justification for making such law the constitutional. Now, in the IPC, there is another type of the jurisdiction, that is subject matter jurisdiction. That offense is not committed in India, but the person who committed the offense, they are Indian. And there is very interesting, that illustration, that a person who went to the Uganda committed the murder, when he came back, the place where he will find, जहां पे भी वो आदमी मिलेगा, वही कोर्ट जो है उसको ट्राई कर सकता है, उसको प्रोसिक्यूट कर सकता है. The third is when neither the person who committed the offense is Indian citizen, nor the place where it is committed is Indian territory. And that is when the offense is committed on a plane or the ship carrying the Indian flag. So that technically that is not, but through it is considered that it is, because it is carrying the Indian flag, so it has the extension of the Indian soil. Here, whenever there is a provision, the effect doctrine will apply you, but the effect doctrine is applicable only the limited sense. And if that effect is not has been established, then maybe that your provision will lose its applicability. And so, keeping in the mind, the legislature has enacted section 32 of the Competition Act 2002 that give extraterritorial applicability. Section 32. The section is before you. You read it. Someone take the lead and read section 32. Yes, please. Any of you?
Yes, sir.
Hmm.
Section 32. Acts taking place outside India but having an effect on competition in India. The Commission shall, notwithstanding that A. An agreement referred to in Section 3 has been entered into outside the India, or B. Any party to such agreement is outside India, or C. Any enterprise abusing the dominant position is outside India, D. A competition has taken place outside India. E. Any part to combination is outside India. F. Any other matter or practice or action arising out of such an agreement or dominant position or combination is outside India.
Then,
Has power to inquire in accordance with the provisions contained in sections 19,
yeah,
20,
stop. So that means what it says, that the CCI will have the jurisdiction notwithstanding. That means notwithstanding where the agreement is entered, where the dominant position was abused, if the effect of that falls on the Indian market, then CCI will have the jurisdiction, and the CCI can have the inquiry as per the provisions of the Competition Act. So that shows the extraterritorial applicability of our Competition Commission of India. Competition Act gives or provide the extraterritorial applicability. Section 32 you can say is a long arm, body arm, लौकिक बड़ी भुजा बना देता है, long arm provision. So this is one of the unique feature, a salient feature of the Competition Act. Now the second salient feature is, you can say, section 54. And section 54 empowers the government to exempt certain sectors from the purview of Competition Act. Suppose government want that there are some budding sectors जिन पे कंपटीशन एक्ट शायद हम लगाएंगे तो उसका अनरीजनेबल रिजल्ट निकलेगा. सो ऐसे में जो है गवर्नमेंट एग्जेम्प्ट कर सकती है, सेंट्रल गवर्नमेंट. परंतु Central government cannot exempt that it is public enterprise or it is private enterprise. Under the MRTP Act, there was special exemption for the public enterprises or business through the government department, but no. Now, any class of enterprises can be exempted. So, the power to exempt is given, and this section keeps the balance that on one side, the we have to maintain the competition on the market, and on other side, if there is a some sector or any class of the enterprises that government want to boost up, so through the notification it passes the order that the provision will not apply, like regional rural bank. And in the case material itself, maybe at the end of it you will find the notification with respect to regional rural bank. There are different regional rural bank whose purpose is to provide the banking services in the rural areas, and that is local banks, region wise. And there they have some exclusivity. So maybe some person can challenge, but because that is necessary for providing the banking services to the common folk, and that's why through the notification under section 54 the central government has exempted the applicability of the competition act. Section 54, I'm reading, that the central government may by notification exempt from application of this act or any provision thereof for a period as may be specified. Maybe all the provisions, maybe any special provisions, maybe for 1 year, 2 year, for any specified period, but to the any class of enterprises if exemption, the reasons are there, necessary in the interest of the security of the state or public interest, in the security of the state or public interest if it is essential. So any class of the enterprises, central government can issue the notification of exemption. Any practices or agreement rising out and in accordance with the obligation assumed by India under any treaty, agreement, or convention by any other countries. Like in our constitution, we have Article 253 that if government has committed on the international forum, then even if that matter present in the state list, center can make the law. Similar is there. Suppose at the international level, the government has promised under some treaty or agreement or convention, so that practice may be exempted. And the clause C is any enterprise which perform a sovereign function on behalf of central government or the state government. Now, this is exempted. Any enterprise if perform the sovereign function or on behalf of the central government. So maybe the enterprise is performing the function, doing the activity, but it doing the activity that is sovereign function. And when we will discuss the enterprise in section 2H of the Competition Act, enterprise includes person or government department. Maybe person or government department doing the business either of production, supply, storage, control or acquisition of goods or services, or having any business related to investment, or the third, the business related to the underwriting of shares, securities, etc. But specifically excluding here, if you see section 2H, पर्सन और गवर्नमेंट डिपार्टमेंट, सो चाहे गवर्नमेंट डिपार्टमेंट हो या पर्सन हो, अगर उसके थ्रू बिजनेस हो रहा है तो दैट इज इंटरप्राइज, और दोनों एट पार विद विल बी ट्रीटेड. Section 3, Section 4 will, Section 5 will apply at par with the any business that is doing through the enterprises or any business that is doing through the government department. But then in the Section 2H, the exemption part says that but exclude sovereign function. Government department जो sovereign function करता है that is excluded. एंड यहां पे सेक्शन 54 में अगर कोई इंटरप्राइज भी है जो sovereign फंक्शन परफॉर्म करती है, so that is also excluded. So this is just the extension of the section 2H. So the power to exempt is the striking feature of the Competition Act. Then come to the next is that there is section 49, and section 49 talk about advocacy, competition advocacy. Competition advocacy provision, section 49. It says that central government, when formulating any policy, can take the advice of the Competition Commission of the India. Or suppose wanted to review the law, can take the help of CCI, because CCI is an expert body. And after this amendment of the Brahmadat versus Union of India, it is only the expert body doing the inquisitorial function, departmental function, and in some way also to some limited sense also the inquiry. And the another forum that is created now, it is appellate tribunal do the quasi judicial function. But the commission also take the measures for promotion of competition advocacy, for spreading the awareness by conducting trainings to the personals of the different enterprises, by disseminating the information that these conducts lead you to the penalty, because these are the violation of the Competition Act, these are the prohibited conducts. Then you know organizing different seminars, research, symposiums. In some years back, CLC organized a program in collaboration with the Competition Commission of India. Moot court competitions on competition issues, and even the internship also, because internship is also the form of the research. So all these aspects are showing the competition advocacy, that it is not only to make the profitable provisions, but also to making aware the folk, to the people, to the relevant you know persons in whom, on whom this act will apply. Okay, so the advocacy provision. Then there is third feature is constitution of the competition fund. Now the commission that has been created, known as the CCI, the CCI required funds to give the salary to its employees. It required funds for the other services, other facility it provided. And for their, if fund is created, a special fund is created, section 51 constitution of the fund. And in this fund, one, central government will credit the amount जो भी salaries वगैरह है. Second, fee, the different, for different activity like inquiry, under notice under section 6 subsection 2, suppose there are two enterprises want to enter into the combination, so mandatorily they have to give the notice under section 6 subsection 2. If they will not give the notice, it is punishable. And for giving the notice, they have to pay some fee. So the another thing that is, the fund created in this competition fund is through the fee fee received under this act, or any interest accrued on the amount that is already there, तो उसका जो ब्याज आ जाएगा. Or suppose some fine is imposed, so that will also be credited into the competition fund. So The competition fund is created so that this commission will not have the lack of, you know, monetary assistance or lack of fund, just to make this competition commission of India as an authority that will not affected by uh, the issues like they are suffering from the funds. Now the next feature is lesser penalty provision. Lesser penalty provision in the cartelization. What is cartelization? Suppose there are different enterprises, suppose jute manufacturing companies और sugar manufacturing companies. So similar जो companies होती हैं, they form the association to protect the interest. It is common. It is common and it is not prohibited. It is not prohibited. Okay. Even the association formation for the citizens, the constitution permits under Article 19. तो cartelization क्या होता है? When the member of the association, till they are only to protect their interest, it is legal. But when they enter into an agreement through their collusive behavior, they all agrees to limit or control the price. वो सारे फिक्स कर लें कि हमें किस प्राइस पे हमें सामान बेचना है. सपोज सारे चीनी के मैन्युफैक्चरर हैं, उन्होंने प्राइस फिक्स कर दिया कि सारे 35 रुपए के भाव से बेचेंगे, कोई कंपटीशन ही नहीं करेगा. सो when the member of the association enters in an agreement to limit or control price, supply, distribution और trade in goods or services, ये जो एसोसिएशन है इसको हम बोल देंगे कार्टल. सो कार्टल को हिंदी में बोलते हैं उत्पादक संघ. उत्पादक संघ. सो जब मेंबर्स जो हैं किसी एसोसिएशन को, जो सिमिलर इंटरप्राइजेज हैं, when they enter in an anti-competitive agreement, this association is termed as the cartelization. And to find, to prove the anti-competitive agreement in the cartelization, because सारे एक ही मेंबर हैं, सारे हर बार मिलते भी हैं, तो अब गद्दारी इनमें कौन करेगा? And so it's very difficult to prove the agreement between the members of the same association. And to allure the parties or the members of the association, there is section 46 of lesser penalty. Lesser penalty कि अगर आप में से कोई आदमी आके हमें इंफॉर्मेशन देगा सीसीआई को, तो उसको सजा में 100% तक की छूट मिलेगी. उसको सजा को 100% तक की छूट मिलेगी. ठीक है. Now there is another striking feature, and that striking feature is section 42, contravention of the orders of the commission. Suppose करो कोर्ट ने कोई ऑर्डर पास किया, so how you will make that order enforceable? The first thing, what the court has passed the order under the CPC, there is order 21 where the execution of the decree is done. Execution is done. Suppose there is the recovery, how that recovery will be done, again the execution issues. And after that also there is non-compliance with the order, or otherwise if there is the order passed by the court and it is not complied, then the options is that to file the contempt petition. So one option is execution, जहां पे डिक्री होती है. बट नॉर्मल जो ऑर्डर होता है, अगर उसका ब्रीच होता है तो कंटेम्प्ट पिटीशन होती है. ओके. देयर इज द एक्ट कंटेम्प्ट ऑफ कोर्ट एक्ट, and high court, supreme court, they have the inherent power to punish. But here if the CCI is neither a tribunal, CCI is nor a court, so contempt of petition to वो contempt of court तो apply नहीं होगा. And so the legislature has taken the precaution that suppose the CCI pass the order, how the CCI will do, or suppose the CCI pass the order of the penalty, how that penalty will be recovered. These are the some of the issues. And for them, The rule of the penalty is that it will be recovered like the revenue area. But section 42 of the Competition Act, you know, cover the contravention of the order of the commission. So suppose the commission pass any order under section 27, and under section 27 the competition commission can pass five types of the orders, and these five types of the order are written in clause A, B, C, D. Cease and desist order, then penalty order, then आपका section 27 में जो आपका होता है डायरेक्ट एग्रीमेंट की एग्रीमेंट जो है वो मॉडिफाई हो जाएगा, मॉडिफाई कर दो, मॉडिफिकेशन ऑर्डर और ऑर्डर ऑफ कंप्लायंस or any other order. If that is not called, then not obeying the order itself is made punishable by the section 42. Section 42 is criminal provision in that respect, and the chief metropolitan magistrate will take the cognizance, and that person will be tried by that way. But the question is, suppose it is a company. Some of may some of you may be thinking, suppose there is the agreement between two enterprises, and the CCI made the inquiry, and CCI passed the order of the cease and desist that you will not comply with, or you have to not apply this agreement, and even in the future you will not comply. Siege, ruko, and desist, not to repeat it in the future. But the company still following that order. In that case, and for there, even when the company is contravening, so there is the presumption clause, and that is section 48. When you read the section 48, it provides the answer to both of your questions. And section 48 says that where a person committing the contravention of any of the provision of the act, that means any of the provision, section 3 भी है, section 4 भी है, or rule or regulation order made direction issue thereunder is a company, every person who at the time of contravention was committed was in charge of and was responsible to the company for the conduct of the business as well as the company. That means the company तो है ही है, but company is artificial person. Company does not have body, company does not have mind. And in section 42 I said that it is a punishable offense not obeying the or not complying the or contravening the order of the CCI. And chief judicial magistrate or metropolitan magistrate, sorry, chief metropolitan magistrate will take the cognizance. But in the case of company, how you will take the cognizance, and to whom you will put behind the bar, because company को तो आप नहीं रख सकते, because that is only in the eyes of law. And so it says that company will be liable, and the person who is in charge at the time of contravention, both will be liable. The person who is in charge as well as the company shall be deemed to be guilty. Wherever you will find this word shall be deemed to be, that means it is a legal fiction. लीगल फिक्शन मीन्स तो फिक्शन फिक्शन और नॉन फिक्शन दो तरह के लोग नॉवल वगैरह या पढ़ते होंगे बुक्स. सो फिक्शन मीन्स that is artificial, it is the creation of law, it is the creation of law. Actually it is not, but law presume it to be. Okay, the person has not to, in the law, if anything done by any person on behalf of the company, it will be presumed that it is done by the company. But because of this technicality, that the company cannot take the decision are taken by actually the person who is in control of it. So let punish them, because company नहीं order मान रही, इसका मतलब कोई उसमें जो बैठा हुआ है वो order नहीं मान रहा है. So that's why to make it effective, there is this type of the fiction created by the section 48. Now uh, there is section 36. Section 36, another feature is section 36, power of the commission to regulate its proceeding. because we know that CCI is the expert body. When it make the departmental inquiry at that stage, departmental action at stage, the principle of natural justice may not be followed. Some of the principle of natural justice may not be followed, but when it make the final inquiry, the finality of the order when CCI made, at that time the principle of the natural justice has to be followed. But see, the court, this is not the court where the CPC will apply. So it will regulate its proceeding by taking into the mind of principle of natural justice and some principles of the CPC, like summoning and enforcing the attendance. If this power is not there, CCI order देगा, कोई आएगा ही नहीं. Requiring the discovery and production of document, receiving the evidence on affidavit, issuing the commissions, and some other power that you will find in section 36, normally to the court, the CCI had. Okay. Now, the next striking feature is to issuing the interim order. Suppose A alleged that B and C enter into an agreement, and that by that agreement he will suffer so much losses. But the rule is, before finding whether the B and C have entered into an anti-competitive agreement or no, how the CCI will pass the order? CCI will pass only after the inquiry. And so wherever there is a provision that allow the forum to pass the order without even hearing the other party, but that is only temporary, interim. So section 32, power to issue interim order. CCI also have the power to issue the interim order. And in the case of Competition Commission of India versus Steel Authority of India Limited, the CCI had, passed this interim order against the Steel Authority of India Limited. So these are the some of the striking feature, and you know you have to make it order wise. So whenever there will be a question on the salient feature of the Competition Act, you can write it. Now come to the second portion, the second thing, and that is
सर ये इंटरिम ऑर्डर है वो सेक्शन 32 है या 33 है?
इंटरिम ऑर्डर.
यस सर.
इंटरिम ऑर्डर का 32 नहीं है. 32 तो हमने पढ़ा है, जो उससे रिलेटेड होता है, आउटसाइड एक्ट से, एक्स्ट्रा टेरिटोरियल एक्ट से. इंटरिम ऑर्डर इज 32, पावर टू इशू
33.
33.
यस
33,
सर.
सॉरी.
यस
हाँ,
सर.
वो मेरे मुंह से निकल रहा होगा. आई एम नॉट अवेयर, बट फाइनली व्हेन ही सेड 33, जब मुझे समझ में आया कि आई वाज थिंकिंग इन द माइंड 33, बट आई एम स्पीकिंग द 32.
ओके
Okay.
सर, थैंक यू.
Yeah. Now come to the next and very important issue, the differences between MRTP Act and the Competition Act. See, on one side you can write MRTP Act, on the other side on the page you can write the Competition Act. The first difference is that on the applicability. The MRTP Act, under MRTP Act, the MRTP Commission was not having any extraterritorial applicability. Section 1, subsection 2, section 2, subsection E, clause E, section 14 of the MRTP Act are designed in such a fashion by not allowing MRTP to cover the activities that are entered outside. And in the famous case of Haridas Exports, Haridas Exports, you can write Haridas Exports versus All India Float Glass Manufacturer Association. Float, FLOAT. Float Glass Manufacturer Association, AIR 2002, Supreme Court, AIR 2002, Supreme Court, page number 2728. So in this case, the court said that the effect doctrine we apply, like it is applied in IPC, but if it is not entered into the Indian market. In that way, we cannot treat it. But the Competition Act, Section 32 specifically says that even if the agreement is entered outside, even if the dominant abuse committed outside, or the combination has been taken place outside, if its effect is on the Indian competition, if its effect is here, so the CCI will have the jurisdiction. So there is the extraterritorial applicability under the Competition Act. The commission under the Competition Act, CCI, has the jurisdiction to try all extraterritorial activity whose effect is on Indian soil as per Section 32. But under the MRTP Act, there was no extraterritorial jurisdiction. Second is Second difference is that under MRTP Act, there was the provision related to unfair trade practices that was added in 1984. Unfair trade practices relating to misleading advertisement, etc. But under the Competition Act, there is no provision related to unfair trade practices. Now, unfair trade practices are part of the Consumer Protection Act 2019. So that is second point of difference. The third point of difference is that under the MRTP Act, the dominance was frown. The dominance was considered as a bad. There was the chapter 3 related to concentration of the wealth. The, the, the concentration of the wealth means the dominance. The dominance in itself was under the MRTP Act was, frowned by the law. बोहे चढ़ाता है लोग या आप ये कह सकते हो that was under the MRTP Act actionable. But under the Competition Act, dominance is not actionable. If an enterprise is in a dominant position, that is not actionable. There is no liability. There is no, liability. There is no power of the CCI to pass the order against only because the enterprise is in the dominant position. But if the enterprise is in the dominant position and then it abuse its dominant position, then it do any act that is categorized as the abusive act under the section 4 subsection 2. So only because an enterprise is dominant position per se is not actionable, but along with dominant position, it must be abusive conduct as mentioned under section 4 subsection 2. The next point of difference